Good morning.
Walk us through the deliberation process and tell us how the jury boiled this verdict down to not guilty.
Well, I think initially, as I said at the outset of this case, in my view, always came down to three words: reasonable doubt and reasonableness. And I think putting aside social commentary and social media, I think the jury methodically walked through the jury instructions, which I have, initially ruled out second-degree murder. I think the commentators who have suggested that this was never really a murder case because there was no evidence beyond a reasonable doubt of a depraved heart, ill will, spite, or malice are actually correct. Next, you go to the issue, I think the jurors probably went to the issue of self-defense. Was there any reasonable basis for Mr. Zimmerman to believe that he was in danger of grievous bodily harm or death? I think they probably tabled that and then went to the issue of manslaughter as suggested by the question that they asked the court, which ultimately was unanswered with respect to a clarification of manslaughter.
Right.
They then went to manslaughter and I think methodically went through those elements.
So basically they sort of it was a process of elimination, as you said, very methodically done. And you mentioned that after 11 hours of deliberating, the jury asked for clarification on manslaughter. It didn't seem to be very clear. Is there any way to have made that option easier to understand?
I actually think the instructions were relatively clear. What your viewers should know is that these instructions aren't sort of crafted off the cuff. They're crafted by a committee of lawyers in order to withstand a potential appeal. And, the judge laid out the three elements. It's unclear to me. I'd be very curious to see if the jurors are interviewed afterward to see exactly what their question was. And it's very telling that they came back and after the judge asked the jurors for clarification, they decided not to follow up.
So we know that George Zimmerman was found not guilty, so we're not going to try to retry him now. But explain, Matthew, to viewers confused about the law and how the events leading up to the fight had no legal bearing on this case.
Well, I think the crux of the matter, as explained, frankly, very well by Mark O'Mara, who did an excellent job, and I think both sides did a very good job with what they had, was what happened during the scuffle. It is an indicia of George Zimmerman being the aggressor if he initiated contact. However, if during the scuffle, George Zimmerman was down on the ground and Trayvon Martin, as I think effectively demonstrated by Mark O'Mara, was in fact banging Mr. Zimmerman's head against the ground, I think the jurors probably asked themselves, what would I have done in that situation? What would I have done to protect myself? For better or worse, George Zimmerman had a gun. That's a separate debate. But in light of the fact, I think the jurors found that Mr. Zimmerman had a reasonable fear for his life. He took out his gun and tragically shot Mr. Martin. But what the jurors did, I think, is they separated that tragedy and their emotion from Mr. Zimmerman's state of mind. Arthel, this was never a whodunit. We all know that George Zimmerman killed Trayvon Martin, but at the end of the day, it came down to what Mr. Zimmerman's state of mind was. And the jurors found that he had an innocent state of mind in the sense that he wasn't acting with a depraved heart, and he was acting reasonably.
Yeah.
And
Matthew,
of course, their view... I'm sorry, go ahead.
No, you finish your thought. I apologize.
I was simply going to say, and then you layer on the element, the critical component of reasonable doubt, and I think that's how the jurors got to where they were, got to where they got. One of our most famous judges, Learned Hand, this is a cliche, and I hate cliches, but I think it applies in this case. Learned Hand, aptly named, said that in our system, based on the Constitution, it is preferable for 10 guilty men to go free than for one innocent man to be convicted. I can't opine on the innocence or guilt of Mr. Zimmerman. I was not on the jury, but I think what happened here could be a manifestation of that maxim.
I want to go here with you, and we still talk about the jury. Ultimately, it's the interpretation of the law by the jury. It's what rules. So, of course, without changing the meaning or legal impact, should some laws be rewritten to make them easier to understand?
Potentially, and that's the age-old question. There always is, although I said jury instructions are written by lawyers in committee well before the trial. Each state has their own set of jury instructions, but then the lawyers, the prosecution and the defense in criminal cases, grapple over or negotiated over wording because somebody's life is at stake in criminal cases and every word matters. I think, however, that this judge, Judge Nelson, did a reasonable job taking the previously drafted jury instructions by the legal committee, which are on the books, and crafted them to apply to this case. And again, I'd be very curious to see what question the jurors had with regard to seeking clarification of the manslaughter charge.
I mean, they simply, I was trying to find it here, but if I recall from yesterday, it was very simple. Can you explain what that means? What is the manslaughter option? Break it down for us.
And the reason the judge, I think, was in a difficult position, and the prosecutor and the defense lawyers were in difficult positions, is they actually needed some specificity regarding what the jurors found to be confusing. Otherwise, they would have been acting in a vacuum.
That's my point. And we close on this. That's exactly my point. It's all about semantics. Semantics are very, very, very crucial. And it just got murky at the end of the day, it felt like to me.
It sounds like it did. Again, I'd be curious to see what the jurors thought. I think, with respect, I think the instruction actually was relatively straightforward. Maybe they wanted to see how it interacted with self-defense, the self-defense charge. But unless and until the jurors are interviewed, we won't know. That said, you raise a good point. I think the state of Florida, in light of the high-profile nature of this case, because one word could matter, may take another look at the manslaughter jury instruction to make sure it's as clear as it needs to be.
And we end there. Mathew Rosengart, thank you very much for your time and analysis this Sunday morning. Good to see you.
Thank you.